5 seconds to go. Start. The section is not intended to apply to acts done purely in a private capacity by a public servant. It must have been ostensibly done by him in his official capacity in execution of his duty, which would not necessarily be the case merely because it was done at a time when he held such office, nor even necessarily because he was engaged in his official business at the time. For instance, if a public servant accepts as a reward a bribe in his office while actually engaged in some official work, he is not accepting it even in his official capacity, much less in the execution of any official duty, although it is quite certain that he could never have been able to take the bribe unless he were the official in charge of some official work. He does not even pretend to the person who offers the bribe that he is acting in the discharge of his official duty, but merely uses his official position to obtain the illegal gratification. His Lordship Suleiman Judge clarified that it is not imperative for the very act which is at the center of the charge to be the official duty of the public servant. This would lead to the inference that an offense can never be part of one's official duty and defeat the very intent behind the enactment of the provision. Instead, the essence of the provision was that the offense must be in respect of an act done or purported to be done in the execution of duty, that is, in the discharge of an official duty. Although the offense would really amount to a breach of duty, it must purport to be done in the official capacity with which the official pretended to be clothed at the time. However, it was made clear that the provision must not be applied to acts done purely in a private capacity by a public servant, but only to those acts ostensibly done by him in his official capacity and in execution of his duty. Therefore, merely because the act was committed at a time when he held such office or when he was engaged in his official business would not make the section automatically applicable. His Lordship Varadacharya Judge, in his concurring opinion, expressed that the question of whether or not the act complained of is one purporting to be done in execution of his duty as a public servant is substantially one of fact, which is to be determined with reference to the act complained of along with the attendant circumstances. It would not be wise nor desirable to lay down any hard and fast tests in this regard. The Judicial Committee of the Privy Council in Gill and Another versus the King, reported in AIR 1948 PC 128, was faced with deciding whether sanction was required under Section 197 CRPC for the prosecution of a public servant charged with the offence of bribery and or conspiracy to take bribes. The court was of the opinion that it was impossible to distinguish or differentiate between Section 270 of the Government of India Act 1935 and Section 197 CRPC, at least in relation to offences of this character. Therefore, the decision in Dr. Hori Ram Singh Supra would be of great assistance in cases pertaining to Section 197 as well. It was observed that a public servant can only be said to act or purport to act in the discharge of his official duty if his act is as such as to lie within the scope of his official duty. Therefore, the test may well be whether the public servant, if challenged, can reasonably claim that what he does in virtue of his office. The relevant observations are reproduced herein below. A public servant can only be said to act or to purport to act in the discharge of his official duty if his act is such as to lie within the scope of his official duty. Thus, a judge neither acts nor purports to act as a judge in receiving a bribe, though the judgment which he delivers may be such an act, nor does a government medical officer act or purport to act as a public servant in picking the pocket of a patient whom he is examining, though the examination itself may be such an act. The test may well be whether the public servant, if challenged, can reasonably claim that what he does in virtue of his office. Applying such a test to the present case, it seems clear that Gill could not justify the acts in respect of which he was charged as acts done by him by virtue of the office that he held. Without further examination of the authorities, their lordships, finding themselves in general agreement with the opinion of the federal court in the case cited, think it sufficient to say that in their opinion no sanction under section 197 of the Code of Criminal Procedure was needed. In Albert Westmead's versus the King, reported in AIR 1948 PC 156, the Privy Council echoed the view taken in Gill Supra and held that the appellant in that case could not justify that the act of fraudulently misapplying money entrusted to his care as a public servant was an act done by him by virtue of his office. In Shri Kantai Ramaiah Munipalli vs. State of Bombay, reported in 1954 to SCC 992, this court stressed that each case must be decided in its own facts. Herein, the bench opined that Section 197 CRPC can never be applied if it is construed too narrowly, since it is no part of an official duty to commit an offence, and the language of the provision must be given its true meaning. However, it is not the duty but the act which has to be examined, because an official act can be performed in the discharge of official duty as well as in the dereliction of it. The relevant observations are as follows. Now, it is obvious that if Section 197 of the Criminal Procedure Code is construed too narrowly, it can never be applied, for, of course, it is no part of an official's duty to commit an offence and never can be. But it is not the duty we have to examine so much as the act, because an official act can be performed in the discharge of official duty as well as in dereliction of it. The section has content and its language must be given meaning. In Amrik Singh vs. State of Pepsu, reported in AIR 1955 SC 309, the appellant was charged under Section 465 IPC for forging the thumb impression of an individual, and under Section 409 IPC for the criminal misappropriation of a certain sum. The court opined that if the act complained of is directly concerned with the official duty of the public servant, so that if questioned, it could be claimed to have been done by virtue of the office, then sanction would be necessary. Stop.